A revocable living trust is the predominant estate planning tool today, taking the place of the will that our parents and grandparents used to use in their estate planning. The problem is that because of tax law changes in 2012 and 13, many families are paying more tax because they have misused or misdrafted their living trust. Hi, I'm Jonathan Alper, and I'm an estate planning attorney and asset protection specialist in Orlando, Florida. So most of us have heard or know the primary two advantages of a living trust. Number one, the living trust allows you and your trustees to use your assets and the income from those assets for your benefit during your life if you become disabled. The living trust avoids the need for your family to have a guardianship appointed where all your expenses and income and investments are run through the court and require court approval. The living trust eliminates the need for this. Second, a living trust avoids probate as long as the assets are put inside the living trust during your lifetime. When you die, the trustees administer the trust, pass the assets to your surviving spouse or your children without getting involved in any court probate proceeding. Living trusts do not provide asset protection. This is a misconception that many people who call me believe that their assets are protected from creditors because they have a living trust. A living trust doesn't help asset protection because you are setting up the trust for your benefit, and self-settled trusts or trusts you set up for your benefit are specifically excluded from any trust protection from creditors that other trusts may offer. Here's the main problem I want to speak about today. In the old days, before 2010, we'll call those the old days, the trusts were designed so that upon the first death in a family, two trusts were set up. One trust took advantage of the unified credit available at that time. It reached 3.5 million maximum, and certain assets were put in that trust, we'll call the credit trust, and any trust over that were given to the surviving spouse in what was called a marital trust. And the purpose was to make sure both spouses use their unified credit. Well, here's the problem. When you put the assets in the credit trust and your children later inherit those assets, any increase in value between the date of the first death and the date the children eventually get it when the second spouse dies are going to be taxed for capital gains. And in today's stock market, there's a lot of capital gains that have built up for many families. So the old way of doing these trusts before the tax law changed, the goal was to save estate tax, which it did, but your trust may have some built-in capital gains that are going to have to be incurred by your children when you pass away. Under the new tax law, we don't need that separate trust to protect the assets from estate tax. You can leave all your assets to your surviving spouse and you still have the use of your credit and the spouse's credit. But look at the benefit. The benefit is that when your surviving spouse dies, guess what? There's no income tax because all the assets will have a tax basis based on the death of the second spouse. So you have what's called a step-up basis to the date of the second spouse, and the family ends up paying much less income tax at the second death. Here's the problem I see. In my practice, people come in and ask me to review their trusts, and I see that their trusts were drafted before 2012 and 13, and they're locked into the old formula, and their families are facing significant income tax at the second death because of what we've seen in the increase in stocks and also in real estate and even their home. So there's a lot of people walking around today with a sort of an income tax liability for their children. Also, I see people who have trusts drafted after 2012, but their attorney used the old form that they created in the old days, and they never updated the form because they don't understand how the change of the law affected them. If you think your family could benefit from an estate planning review, either looking at your old trust documents to make sure that they are consistent with current law, or if you're in the process of estate planning and want an estate plan and living trust that is consistent with and optimized for current tax law, please give me a call. Our phone number is 407-444-0404, and we're here to help.